Building mutual trust. If you go to European projects on that website, you will, for example, find a reference to this project, Building Mutual Trust, which provides training materials, yeah, for legal interpreters and translators. This is the website of that particular project. And the interesting thing is that all these European projects are also linked to the EULITA website. So you can find, like sort of one place from where you then can branch out to the various projects. Another European project was the one that's recently finished, Improving Police and Legal Interpreting, where they produced like 6 videos on police interviews in 6 member states and how they were conducted with the help of an interpreter. So, best practices in 6 member states. The other one is Vigo, and this project, another European Union project, this project addresses particularly the issue of video conferencing.
I don't know. I remember how it used to be. It used to take months for a judge to hear a witness from a different state. Today, the judge sits down before a camera and the witness is in another state with his interpreter. Bang, bang, it's ready. Do you understand? Where's all the beautiful bureaucracy, all the paperwork, all the creative thinking about how to transport the witness to a hearing, where to find the interpreter? The time is really bad. We are losing our technological advantage. Today it is video conferencing. Who knows what they'll think of tomorrow? Remember, this program of justice, electronicization, won't bring anything good for us.
This is what he is talking about. Your interpreter is in one place. Your asylum seeker, your witness is in a different place. At the bottom, your interpreter is with the refugee, asylum seeker, witness, whereas the court or whatever is in a different location. Or the third alternative might be that your, let's say, arrested person with his lawyer is in a police interview and your interpreter is in another country. Who knows? These are situations the way it really looks. This is an example in the Netherlands. And you have your police officer and your interpreter, sitting with someone in an interviewing room before a screen. The judge looks at the screen, miles away, different city, different location. And then this is the view from the courtroom, the public, the audience in the courtroom. Fingerprints, documents, whatever you put on a document reader, and they are transferred to the screens of the parties. This is how it works. And it's a reality. It's being done more and more and more in the member states or between member states. And we have been part of a project looking at interpreting in video conferencing in criminal proceedings, and for example, have devised all kinds of modules, like for example a training module for the interpreters, but also a training module for police officers or judges working in interpreted video conferences. I'm not going to talk about the training institutes, but obviously, as I said, looking at the directive, there is a huge, huge challenge for the training institutes. Who is going to train these qualified, certified, accredited interpreters and translators? What are the competencies that they have to have? How do you test these competencies? So those are enormous challenges for training institutes in all the member states. And you can do it from the competences one has to possess. You can also look at it from the kind of, sort of core curriculum that maybe should be taught. And you can see some of the issues that probably need to be included in that kind of training. Now, finally, a couple of minutes, new developments. As I said, this roadmap designed by or under the Swedish presidency was launched with the publication of the first directive on interpreting and translation. The second directive, earlier this year, in May 2012, was on the right to information in criminal proceedings. For example, this is essentially about the letter of rights. You're arrested, and then you're entitled to a number of rights. For example, the right to interpretation and translation is an explicit right in that directive. The directive even includes a kind of a model of such a letter of rights. And again, under C, you see the right to an interpreter and a translator. And further on in the directive, it's explained what they mean by help of an interpreter. Essentially, it repeats, it takes up the issues of the convention and of the directive, but it's there again in another context, as it were, in the letter of rights and the right to information. And finally, we come to the reason for the occasion of this meeting, which is that the European Commission, in this new mindset, this new philosophy of what the European Union should be, has also become very much concerned with the position of victims. There's going to be another directive in the future about vulnerable persons, which could be victims, but could be also, for example, people with disabilities, the hard of hearing, the deaf, or could be children. Yeah? But this is another issue, which is the issue of victims in criminal proceedings. And that's a major concern of the European Commission today. If you look at the website of the Directorate General DG Justice, you will find victims on the menu on the left there as a major concern. And particularly, it says that those who are most vulnerable or who find themselves in particularly exposed situations, such as persons subjected to repeated violence in close relationships, victims of gender-based violence, that deserves the concern of the member states and of the European Union. And this is exactly what this project SOS-VICS is about. That project SOS-VICS is now heavily, strongly supported by the very recent publication of a directive, a third directive. As you can see, this is the reworking again of an earlier framework decision. And if you look at the framework decision, it dates again from 2001, 11 years ago. They published a framework decision. And when they publish a framework decision, you can bet on it that that is the result of 5, 6, 7 years more of preparatory work. So you can have an idea of how long it takes within the European bureaucracy, as it were, from start, conception of an idea, to a final legal instrument. But anyway, we do have a directive on the rights, support and protection of victims of crime. It's a directive. And this directive, again, very specifically mentions interpreting and translation. Yeah? And you can, these are long passages, which we're not going to go into, but it's important for you to know, more articles on interpreting, it's important for you to know that 3 recent directives on interpreting and translation, on the right to information and on victims, that all these 3 directives explicitly make interpreting and translation as a central focal point of their objective. What does that mean? What it means for you as young people is that interpreting and translation, no matter how, is going to become much, much more important and crucial in criminal proceedings. Therefore, there's an invitation or an opportunity out there, to do something with that opportunity and respond to it. I'm going to skip that. It's again, like a sort of a recommendation of the Council of Europe to the member states, how they can, help the member states to come to terms with that new challenge, that new directive. For example, recommendation 31 asks the member states to pay special attention to the interests and difficulties of persons in vulnerable situations, including Roma women and girls with a migrant background, women and girls with disabilities, support, etc., etc. Yeah, the same philosophy that permeates the directive. And again, training of professionals is recommended, as you can see in 5b. Interpreters need to be trained to work in this particular area and meet these challenges. So therefore, I'm extremely pleased with these developments. It's taken a long, long time. Remember that we started in 1997, 1998. It's now 2012. But one has achieved a couple of things. I mean, we do have directives, and we've been extremely lucky, really, with the Treaty of Lisbon, which completely changed the ball game in the sense that the member states are now obliged to implement those directives, and that I think is not only from the perspective of fair trial, safeguarding individual rights, etc., is a major step, but also putting it in purely almost materialistic, pragmatic, professional terms is a great, great challenge for training institutes, but also for you as individual interpreters and translators. Thank you very much for your attention.